The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here today for the submission of 4 different cases. The first one is State of Iowa versus Donald Wittenberg. That is hereby submitted without oral argument. The next case is State of Iowa versus Jeffy Harbach, and it is also hereby submitted without oral argument. The 2 cases we have set for oral argument will begin with the first one, State of Iowa versus Iowa Juvenile Court for Plymouth County. Looks like the parties are ready to begin. Ms. Reinkoester.
Thank you, Your Honor. May it please the court. Considering it's nearly 120 years old now, it feels a little odd to call the juvenile court new. But in the grand scheme of the law as we know it, it is a modern creation. And as a modern creation, it can only do what it is authorized to do by statute. And this concept isn't new. It's a concept that has been recognized by this court before in sister cases, one of which is the State versus Iowa District Court for Warren County. And in that case, and the cases it cites, this court found that the juvenile court violated its authority when it ordered placements for juveniles in consent decrees or adjudications that were not expressly authorized by statute. So those cases recognize the idea that the juvenile court can only do what it is expressly authorized to do. And here, the juvenile court did something that is not provided by statute. It reconsidered a waiver order months after it had already waived the case to district court and waived its own jurisdiction over the case. After doing that, there's nothing in Chapter 232 or any other provision that allows the juvenile court to take back its jurisdiction. And I think the court in Maryland, in the Franklin P. case, said it well when they said a motion to reconsider a juvenile waiver order is unique. It isn't a typical reconsideration because it isn't simply a court changing its mind about its own opinion in an interlocutory way. Instead, it is a court taking jurisdiction from another court that rightfully has it and divest that court of the jurisdiction it was given by that court. And that is a power the juvenile court has not, it doesn't have the power to do that.
What am I supposed to make of the district court statements at this hearing that sort of invited this?
I think that was a mistake on the district court's part. I don't think the district court has any authority under its own jurisdiction to give it back to another court. I think that ended up causing some confusion in this case for the parties because then the parties did what the district court thought they were authorized to do. But the district court was also mistaken that the juvenile court could take its authority back.
What about the fact that the state tried to get rid of certiorari from what the district court did? It was too late, we denied it. Does that mean now it's too late to go look at what the juvenile courts do?
I assume because you granted the second writ, no. But I do think probably the first writ was filed maybe too promptly on our part in case that order ended up being the final order. In this particular case, it wasn't because the juvenile court then sent it for a hearing to hear evidence and argument on both the jurisdictional issue and the reconsideration issue. So I think in that particular case, it isn't too late now to challenge that order because the order taking it back is now the order that we are appealing from.
Appellate jurisdiction, the case is either on appeal or it's in trial court. It can't straddle both simultaneously.
We can't, until, in the 1970s, from the 60s and 70s, in the code provided that the district court and the juvenile court had concurrent jurisdiction over cases. That didn't necessarily mean they both were authorized to work on the case at the same time. The code expressly provided for that. That was removed from the code many years ago. So I don't think that there is, by statute, any concurrent jurisdiction between these two courts. It's either the juvenile court has it or the district court has it, and there's really no in between, unless we're talking about youthful offenders, in which we are not doing here.
difference if the juvenile court reconsidered its order before the trial information was filed?
I've thought about that question a lot because I don't think our statutes also authorize that reconsideration, but I can see why, in the Wisconsin case, in the, I don't remember the name of it at this moment, the Variant M case, where they said it was authorized to do so up until the point where a criminal complaint is filed. I think that there's some practicality to that because at that point, the district court has not exercised its jurisdiction over the case yet. And so it's sort of, you're kind of in a limbo a little bit before the district court takes over.
The initiation of the case as the filing of the trial information. So if the juvenile court says, well, I want to take that back before anything's done, maybe that makes a difference, maybe not.
Makes sense too in that would be permitted, not only because the district court has not yet exercised its authority, but there might be relevant reasons to have a juvenile court reconsider its waiver order in a true sense. Perhaps it wholly missed some evidence that was presented at the hearing, or it failed to consider necessary factors under the statute. Then it would make sense for them to have to go back and make sure they get it right.
Follow-up question then would be is, if your argument is that the juvenile court can only do what's authorized by statute or rule, what is the statute or rule that would allow that?
I mean, it would have to be the civil rule 1.904. But that also has a 15, I think it's 15 days that you can file a motion to reconsider a motion to reconsider. Perhaps if a trial information got filed before the 15 days, that wouldn't be permitted anymore because then the district court has taken its jurisdiction over the case. But I think that rule, until that happens, could authorize the juvenile court to reconsider its order.
Correct? We're in the middle of proceedings. So isn't this kind of all for naught? Couldn't the district court, if it sounds to me like district court and juvenile court are perhaps maybe on the same page, couldn't district court have just said, I'm going to just, I'll entertain a motion to dismiss the whole thing and let them just start over and do it again in juvenile court? Could they have done that?
I don't think so. I don't know that any of the rules authorizing motions to dismiss would apply in this case.
It sounds to me, well, maybe the state wouldn't have moved, but if the defense made a motion based on the same arguments that are being made by the juvenile court's order, new evidence, all that business, and if the district court was persuaded, which it sounds like it wouldn't have taken much to do, couldn't that happen?
I agree that it wouldn't have taken much for the district court to do because the district court was explicit that it was not entertaining any evidence on the merits of whether or not this should remain in juvenile court or district court. It purely decided a jurisdictional issue and allowed evidentiary information in for offer of proof only, and it made no comments about whether it felt that way either way. And again, I don't think that this is authorized under the motion to dismiss rules. It would also, I think, run afoul of the idea of res judicata. Now we have a district court sitting in, as an appellate court, essentially, criticizing the juvenile court's order, saying, I disagree with it, so I'm going to get rid of it. And I don't think that's permitted under our rules. And I think we have cases that say that too, that we can't have district courts sitting in appellate review of juvenile court orders, because then we just have constant conflict between the two courts. So, I mean, failure, without anything in the statutory scheme that allows the juvenile court to reconsider its order, or the district court to yield its jurisdiction to the juvenile court for further proceedings, both things that were done by the district court and the juvenile court are unauthorized by statute in this case. And so because of that, the child in this case, relied on the rules 1.1012 and 1.1013 to do a change to a final judgment or order. And in this case, we know case law is very clear that this is not a final judgment or order, that venue changes and jurisdictional changes are purely interlocutory, and that those orders can't be considered final for purposes of appeal either. And we also have the issue of the timing, which I know I mentioned in my brief, but I think this is very important to say again, which is that if really the only limit is a 1-year limit on the juvenile court being able to reconsider its order, I mean, that provides no guidance that could, interfere with the district court proceedings at any stage of the...
Was this case the trial date when the juvenile court or purported to reassume, either way, will decide jurisdiction of it?
Know the answer to that. I know that he was arraigned, and a trial date had been set at the time that they filed the order in district court. But I would also note that after the district court, stated it believed the juvenile court still had jurisdiction to review its own order, it took the child 2 months to file that order in juvenile court. So it sort of sat back and waited for reasons I'm not sure of. So then we have, yet another delay in making this determination. And I think these constant delays and this ping-ponging back of jurisdiction is really antithetical to the entire juvenile code and the reasons it exists.
Following up on the Chief's question, what about using Rule 2.33, which would allow the district court on its own motion to dismiss a criminal case in the furtherance of justice? Could they do that? Could the court do that in order to allow it to be reinitiated as a juvenile delinquency proceeding?
I don't know the answer to that question. It feels to me that it goes against the idea that we would allow a district court to review a juvenile court's order. That's what it feels like. It's the district court saying, I think you got it wrong. I'm supplanting my judgment for yours, and I'm dismissing the case because I think it should be somewhere else. And I don't think a district court has the authority to supplant the judgment of a juvenile court. I mean, I think that's the fundamental issue there.
The justice, though, seems to be bolstered by all of the times best interest is mentioned in 232, doesn't it?
So I have two responses to the best interests. One is that, that provision expressly states that it's the best interest of the child under the jurisdiction of that court. That's exactly what we're disputing, that court no longer has jurisdiction, so that isn't a relevant concern anymore. And the other thing I would point is also, you said Justice Mansfield in State versus District Court for Warren County, is that provision also expressly provides that what should be done should also be in the best interest of the state. Those things are considered in equilibrium. So we can't just look at the best interest of the child. The state also has an interest here. And in this particular case, the juvenile was waived to district court. He challenged that on a reconsideration order, lost. We filed a trial information and proceeded against the child in district court. The state is entitled to the permanence of that decision. Otherwise, it puts lots of prosecutions and juvenile cases in limbo if we have this idea of treating a child like a hot potato. Then if we say that the juvenile court can reconsider its order at any time, does that mean then too that after it took back this jurisdiction, if the state filed an order saying we have newly discovered evidence and now we'd like you to send him back to district court, that then another 2 or 3 months could go by while that decision is being made, and then the juvenile court's right, that's true. He couldn't actually go to any of these facilities. So now we're going to send him to district court. I mean, this could be a never-ending back and forth based on whatever newly discovered evidence is presented to either court. And because the statutes don't authorize that, it's not permissible. And I think from a policy standpoint, it's not, a favored outcome.
Yeah, I'm in trouble about the notion you have a waiver hearing. The hearing is coming up. Everyone knows there's a hearing. And then the defendant, the child, is allowed later on to say, well, I didn't have enough time before the hearing to come up, just research the available options. So here's some others that existed at that time, but I wasn't aware of them then. That seems to me to treat the concept of newly discovered evidence pretty broadly.
Correct, and I think that dovetails with the second part of my argument, which is that I don't really think anything that happened at the hearing was newly discovered evidence. I think this was simply, I didn't like the result I got the first time, and I had my expert continue doing research that she was doing at the time, but I didn't alert anybody of that. So I want another chance to give you more information that I could have given you the first time around, or I should have at least sought a continuance to say, I am looking into this, and I would like more time to show you what available options are for me. None of that was done here. And I think although it's labeled a motion to modify the second time, I think it really can be read, especially when you see the material that was offered at the hearing in that case, in that second motion, as to in the evidence in the first one. that it simply is just a second motion to reconsider. And under that, if we're going to apply the civil rules under 1.904, you only get one chance to do that. So there are no subsequent motions to reconsider. So I think, even applying those rules here, it doesn't lead to the outcome that the defendant would want. Thank you.
Good morning, and may it please the court. Ms. Reinkoester. In my arguments today in support of the order of the Juvenile Court of Plymouth County, I'm going to be circling back again and again to the principles of Chapter 232 and the underpinnings of our juvenile court system, why we treat juvenile offenders differently than we do adult offenders. I think that context is important no matter what arguments that the court chooses to follow, whether the state's arguments or my arguments.
Right away, and I would be an easy one to persuade about the 232 stuff. I tried to think of something that would be similar, and it seems kind of difficult for me to wrap my head around. 232C is emancipation of minors. That involves a minor who can file in juvenile court if they have satisfied certain things. And for example, I'm going to name you one of the things. The financial self-sufficiency. Okay, let's say that happens, and there's other things. Let's say the judge is persuaded, yeah, you're emancipated. So they have a hearing, they enter an order, and the order, which has to take best interest into consideration, just like everything else. So the juvenile then can do things such as enter into contracts, enter into a binding contract. Let's say a couple months later, all of a sudden, they realize, no, he's not self-sufficient. He used to work at the movie theater. Now he doesn't make any money at all. He can't pay for anything. Can they undo that? Why is that any different?
That would be an example of the special nature of the juvenile practice. You've got defendants, or in your case, minors seeking to be emancipated, who their development is a continual process, and their evaluation at the court the first time may not be correct. So there may be other information that needs to be obtained, like in this case where the defendant's counsel was seeking to have an expert try to locate placement for the child, whether in-state or out-of-state. I know the state had talked about the delays in that. Largely those are because of the difficulties in finding resources for juveniles, trying to figure out if what type of resources are needed. Do you need to exhaust state versus...
To this, though, do you think that emancipation could be undone once they've bounced it from juvenile court and they've put a label on it and he's starting to get sued in district court because he can, and all of a sudden the facts have changed? Could it go back? Could he say, I want to be unemancipated? I want you to undo that order?
So the minor would be requesting to be unemancipated based on their experiences?
Case here, the minor wants to go back. Hasn't the juvenile court in the emancipation, when they wrote that order, emancipation, and floated it into the air, how do they ever get to touch it again?
And that has ramifications with parental rights and other things too, certainly, but that would be difficult. In this case, however, I think because the juvenile court system and the district court have an interplay because of the possibility of having somebody go to adult court for a certain offense or remain in juvenile court, that connectedness, I think, is what would allow what we're asking, which is for the ability of the juvenile court to reach out if the circumstances would warrant and if evidence would show that it was important and necessary, could reach out and take that.
When it's too late? I mean, if we're in trial, the jury's out, is it too late at that point?
Late at that point. And I know that there was some discussion of...
Is that dividing line that we should find?
Call to make. There was some discussion of the arraignment being a possible milestone. Certainly, if the case was to trial, it wouldn't be necessary. It wouldn't be appropriate to do so. A lot of what I'd be talking about in a moment would be the circumstances under which it would be appropriate to even consider that.
The line, why wouldn't the filing of the trial information be too late once you have the court actually asserting its jurisdiction over the defendant?
From a practical standpoint, if there was discovery occurring in the criminal case that might yield information that would be relevant to the juvenile case. If experts were retained for psychosexual reasons, things like that, that might be the source of information that could lead a juvenile court to say, wait a minute, maybe this defendant does not need to be in adult court and should be brought back to juvenile court.
Why not do what is all over the statute in juvenile court 232 in other places, concurrent jurisdiction? Those are magic words. They get used all the time. So if the legislature wanted the juvenile court to be able to hang on, they know how to do it. They know how to do it. We grant concurrent jurisdiction all the time in juvenile court. We let big court handle things, and then we decide whether or not we're ready to let go of it. Isn't that a perfect way to handle this situation? And the lack of any concurrent jurisdiction language, doesn't that perhaps tell the court you can't do it?
If you take the position that the lack of mention of concurrent jurisdiction is a legislative intent, the fact that it's not in there might indicate that the legislature had not considered that, or that's a vacuum in the statute that we're trying to fill by trying to come up with an appropriate procedure that still fits within the statute and the goals of the statute.
This is going to be a simple-minded example, but this is one way of looking at it. I'm the trial judge in Polk County. I grant a transfer of venue to Story County. A case goes over to Story County. It's being handled over there by a judge in Story County. I decide, as that case is nearing trial, I've got some more information. I shouldn't have granted the transfer of venue. Can I just call that case back?
I don't believe you can call the case back without due process or without an inquiry. And I believe that the juvenile court in these matters would need to have a compelling reason to even consider recalling, and then would have to have an evidentiary hearing and be able to justify the action.
Is the answer to Justice Mansfield's question yes?
Okay, let's pretend like you could undo it. I'm not persuaded about the compelling reason, and I do have a hard time finding that the requested relief wasn't already known. How can that be newly discovered? It was not a place or a level of care, excuse me, or a funding that was previously not available now. What is new about it other than that expert didn't know?
I think that's a valid criticism of the process of trying to get the information to the juvenile court. This was not my case at the trial level. I'm the appellate counsel, so I'm following the record the way you all are. The impression that I got from it was that there were difficulties in terms of locating suitable facilities, suitable people to do treatment. Some of the facilities in question were primarily substance-oriented. Yes, it does.
Stuff. So how is that unique?
I think it's unique in the sense that the juvenile in question deserves the chance to have a full inquiry made. And certainly there's been some question about the pace at which that was done or the depth to which it had been done. I do believe that the process requires us to make the inquiry and provide that information to the court so the court can make the decision about whether or not the waiver should be altered that way.
Agree that, or do you agree that the court's exercise of authority has to be either by statute or by rule?
That would be correct.
In this case, the motion was filed under 1.1012, which applies to final judgments. Is that correct? So our case law says that this is not a final judgment or order, then just as a matter of procedure under the rules, this was an improper motion. Is that right?
And that would be the logical conclusion to the way you've played it out for me there, certainly.
Leave you if you have an improper motion, there's no other statutory authorization.
I guess I don't have at the tip of my tongue the case law regarding the finality of those orders.
Let's assume that's the case, that these are not final orders.
My position, certainly. I think what I would respond to that would be that if you take the state's arguments about once the waiver's in, then that's it. there's no going back, there's no two-way street, it's a one-way street, then there's a finality there. And so you could bootstrap an argument that because of the finality of that particular order, that you could attempt to use the rules of civil procedure to treat that as a final order.
The problem, it seems to me, is, 1.0, whatever it is, rule 1.1012 really doesn't have anything to do with this. I mean, in theory, it ought to be easier to modify a non-final order than a final order, right? So
True.
1.102 is the rules of the game when you have a final order. But here you don't really have either. You have an order that handed the case off to a different court. And so that seems to me even more problematic than either a non-final or a final order. That's what strikes me.
Well, I think part of the issue could be that we're using the rules of civil procedure in a lot of different ways, including using them in juvenile court, when perhaps another set of rules would be better. We don't have them certainly, but I think there's some difficulty that practitioners have, at least that I'm aware of, with using the tools of civil procedure to try to get things done in juvenile court. And so,
The case is either in juvenile court or district court. It can't straddle it simultaneously.
exist in both, but I think that line between the two is more fluid than the state would admit.
Iowa authority of an unwaiver. I call this an unwaiver.
Waiver? I really don't. I mean, I guess the closest I could come to it would be the Wisconsin case and some of that dicta.
Because I know the juvenile laws are very different across the country, but have you ever seen this in Iowa? I've never seen it.
Unique animal.
Practical matter, what happens to the trial information?
Well, the suggestions about the court acting to dismiss in the name of furtherance of justice, for example, a trial information doesn't necessarily go away. I mean, by operation of law, it could be terminated if there's a change.
Case, right? It's docketed with a criminal number. There's a trial information out there with pending criminal charges. What happens to that case?
I think that goes to what we had talked about a little bit earlier when counsel was here at the podium, the idea that, I've lost my train of thought, hang on. Could you repeat your question? I'm sorry.
Well, I mean, the juvenile court doesn't have jurisdiction over this case, right? And I don't even think, unless I'm wrong, I don't think the DHA would have authority over conviction at this offense level. Is that right?
Would be correct.
Well, you have an order that says one judge is supposed to do something with this case that by statute, the judge doesn't even have authority to adjudicate. And then you've got a case out there. So what happens to that case?
Well, I think that could be addressed if the district court and the juvenile court were of one mind in terms of how to handle the matter. The juvenile or the district court could certainly act to dismiss or to do some other procedural remedy, as was discussed a bit earlier. But you're correct that the trial information would be out there. It's part of that system.
Jurisdiction, and then it circles back to my earlier comment that I see no statutory provision for concurrent jurisdiction. Because if you've got the trial information live, and you now are saying juvenile court's back in the game, isn't that concurrent jurisdiction?
There would be two courts acting in tandem, so that would be concurrent jurisdiction. I guess the way around that would be to avoid a situation where you've got the district court in competition with the juvenile court and maybe something where they're working together for the common goal of the need for going back to the waiver, which is that you've got a certain situation with a certain juvenile defendant who it would benefit that juvenile defendant to return to juvenile court.
The district court have done its own waiver analysis and sent the juvenile back?
I believe so. We had that tantalizing sentence there where the district court mentioned the possibility but never followed through and never carried out the analysis.
Scheme seems pretty specific about that if it's properly in district court to begin with, there are certain times when a district court can reverse waive. But are you suggesting that this would fit under a reverse waiver or just a more generalized?
Reverse waiver because that's a creature of statute. I feel more like this is a situation where we're kind of scrambling to fill the vacuum in the statute, while trying not to run afoul of jurisdictional and other issues. But
And the statute is just the ability to reconsider? Is that, what's the vacuum exactly?
vacuum, and so what we're trying to do is to figure out a solution that works within the machinery of the statute and the juvenile court system.
To the policy arguments your opposing counsel made that this will be this ping-ponging back and forth and uncertainty whether a case could be recalled at any moment would be disruptive and counterproductive.
Be an issue simply because I know a lot of juvenile judges, I know the juvenile system in this state. If a juvenile judge felt there was a need to revisit the waiver, I feel like they would be equipped with the expertise and the knowledge to know when that would be appropriate and necessary, and then be able to conduct the hearing to find out the information to justify it, if it would be allowed. I see my time is just about run out. Thank you.
May it please the court. So Justice Mansfield, your question about venue was a good one in the sense that there's a case from Florida that contemplates almost that specific thing, except that it wasn't the original court taking back jurisdiction. It was a second court, or sorry, just taking back venue. It was a second court after the venue had been transferred decided that venue would be appropriate elsewhere. And that case is State v. Gary. It's 609 South 2nd, 1291. And in that case, the Florida court said that the second order changing venue was inappropriate because it amounted to appellate review of the legality of the first order. And that is not permitted. And changing gears a little bit to the idea of a motion to dismiss, also from a practical standpoint, that could also lead to like ping-ponging. And that is, let's say the district court decides that they didn't like the juvenile court's analysis and that it should have remained in district court, or sorry, juvenile court. And so they dismiss the case. And then the state refiles its petition in juvenile court. And the juvenile courts said, I already said this child should be waived. I waive him again. And then we have a district court that says, I just disagree. So I dismiss the case. I mean, that's just two judges disagreeing with each other on the district court level that would be a constant circle of who is correct. And I think because the statutory scheme doesn't contemplate that isn't permissible under the rules. And in terms of counsel saying that there's some kind of vacuum, I disagree. I think the legislature has made it clear that you get one shot for either waiver or reverse waiver, and then the court that has jurisdiction proceeds. But even if there is a vacuum, there's only one place that vacuum can get fixed, and that's at the legislature. If they believe that a juvenile court should have the authority to revisit its order, then the legislature should say so. And I understand that the Wisconsin Supreme Court crafted quite a remedy in its order on a similar case. But it did so under a provision of the Wisconsin Constitution where they believe that if there is an inadequate remedy, that the Wisconsin Supreme Court has the authority to craft a remedy in its place. I don't think we have a similar provision here. I think adequate remedies have to be provided by the legislature. And that is where the child or the defendant in this particular case should look for that remedy. And to the newly discovered evidence part, in the second part of our brief, we agree that there simply is no evidence here that was new. That under the due diligence standards that this court has laid out since Campagno, that information that is known or information that is knowable and that the person is put on notice of knowing before the end of whatever the procedure is, either trial, motion, in this case, motion to waive, they have the obligation to alert the district court that there is ongoing research and to ask for a continuance in order to conclude that research. That was not done here.
What called the known unknown versus the unknown unknown? Is that what we're talking about?
Something like that. It's in juvenile cases, it's sort of hard to even conceive of newly discovered evidence because pretty much everything is before the court at the time. It would have to be new evidence, as in this case. His strongest argument in favor of waiving back to the juvenile court was, I've been very compliant with my treatment so far. That's not newly discovered evidence. That's new evidence. And if any juvenile at any time, once they've been waived to the district court, could say, look how compliant I've been, you should send me back to juvenile court, we could have people being sent back to juvenile court disrupting district court proceedings all the time. And because that's not contemplated by the statutes here, the state does not think it's permitted. And so we ask for you to reverse the juvenile court's taking back of its jurisdiction. Thank you.
Versus Iowa Juvenile Court for Plymouth County is hereby submitted. And we will just have a brief pause while the next attorneys prepare for in re the marriage of Frazier.